Our panelists for this presentation, first, Marvin Schechter is the founding attorney at Marvin Schechter Law Firm in New York. He's a graduate of City College School of Technology, where he received a bachelor's degree in civil engineering, and Brooklyn Law School, where he received his JD. He has a wide range of experience performing legal services for a cross-section of the construction industry, lectures regularly to contractors and management groups through the country, and has taught construction law at NYU and City College School of Technology. He's authored a monthly legal column in Construction Magazine, the Associated General Contractors of America, and has articles published in other leading legal and construction periodicals. Joining him on the panel is Ray Wickenheiser. Ray is the director for the New York State Police Crime Lab System, headquartered in Albany. He has over 35 years of forensic science experience, with 18 of those as a crime lab director in local and state crime laboratories. In New York, Ray is the co-chair of the New York Crime Lab Advisory Committee. Nationally, he is a member of the Forensic Science Standards Board for the Organization of Scientific Area Committees for Forensic Sciences. He was part of a working group, and I had forgotten this, as I also served on the same working group, on national best practices for sexual assault kits, a multidisciplinary approach. He also is an adjunct professor teaching criminalistics at Montgomery College in Maryland. And if you want, for any of these, I'm just giving a bird's eye view of the panelists' qualifications. Their full short bio is contained within your materials. Paula Wulff is the chief of the Forensic Science Law Unit at the FBI laboratory in Quantico. She has been the FBI Lab's chief legal counsel since 2009. During that time, she's participated in changing the FBI laboratory's discovery practices to its current open file response process. She participated on a subcommittee of the National Commission on Forensic Science, as well as many Department of Justice interagency task forces dealing with forensic and legal issues. And prior to joining the FBI, she was a program manager for the National District Attorneys Association DNA program, and prior to that, she was a prosecutor in the 30th Judicial District of Tennessee, which is Memphis. Matthew Gamette is our moderator for this panel. He is the Director of Forensic Services at Idaho State Police Forensic Services in Meridian, Idaho. He started as a biologist and DNA scientist, and he began his career with the Idaho State Police in 2008. I earlier indicated to you when Matthew gave his opening or his welcoming remarks that he is president of ASCLD, and as president of ASCLD has served as the chair of the Consortium of Forensic Science Organizations, and he was selected and currently serves on the NIST Organization of Scientific Areas Quality Infrastructure Committee. I would turn it over to Matthew.
So we want to start out by talking about some new changes to the New York State law. I know many of you are from New York, and these changes will impact you. So we're going to start with Ray Wickenheiser. He'll explain some of the changes and how they'll impact the lab. And then we'll go to Marvin, and he'll talk to us a little bit about the defense perspective in New York. We'll then go to Paula, and I'll finish up. So Ray, we'll let you take it over.
Sure. Thanks, Matthew. I've got some slides there, so I guess if we could get them up. Thanks, Matthew. Okay, so just kind of a outline of the talk I'm going to be giving. So first I want to talk about the mission of crime labs. Then I'm going to talk about accreditation, records, and oversight in terms of this is very specific to New York State, but a lot of it applies to crime labs across the nation. I'll just try to highlight what's unique to New York and what applies to many of the crime labs. I'll talk about the current discovery, which is under 240 in New York, which will be changing to 245, mostly .20, which applies to crime labs, and that will go into effect at the end of the year. I'll talk about the discovery law and its impact on crime labs. I'll talk about resources and what it's going to mean to crime labs, decision points, and a path forward from my perspective. So a little disclaimer. So everything I'm going to say is Ray Wickenheiser's opinion, not that necessarily of the New York State Police. So when you think about crime labs, and this is true of crime labs across the nation, what is our mission? And that is to maximize the value of evidence. So we want to try to do it in a timely fashion. We want to preserve the evidence so it can be retested. And what we see ourselves as is objective, scientific, data-based evidence. So the data's there. Anyone else can relook at that data, can reanalyze, and find the same conclusions. Acknowledging that there are things when people go to crime scenes, they fume for fingerprints. To try to get that in exactly the same conditions sometimes can be challenging because obviously we'll visualize the fingerprints go from there. But in essence, all of that will be documented and will be available for retesting. We feel we have the public trust. It's really important to try to get it right the first time, but acknowledging we're all human, and part of that, and a huge part of it, is when there is an issue, it's up to the crime lab to be the first to step up, own it, learn from it, and prevent the reoccurrence. So we call that a nonconformity or have a corrective action and have procedures for all of that as part of accreditation. We're public servants. We obey the law, including the discovery law, and part of our mission is to provide the best value for taxpayers. We're all career public servants. In essence, we could make better money elsewhere. Forensic joke there, but believe deeply in the crime lab mission. So really, that's who we are. 95% or so of crime labs are local and state, 5% roughly federal. So you're looking at probably most of the crime lab productivity for the state comes out of New York State Police and the other 19 or so labs within the state. So there's 20 labs within the state. Half of those are toxicology, and the rest are mostly smaller local labs, including city NYPD and ours, New York State Police. The oversight for crime labs within the nation, and I believe there's somewhere in the neighborhood of 10 to 12 sort of full commissions that operate somewhat like New York State Police. So we have full oversight by that commission. One of the individuals on the board, Mr. Marvin Schechter, was on that commission for a number of years as well. Also, as part of that is a DNA subcommittee which oversees everything touching DNA. The New York Commission on Forensic Science is all made up of volunteers as allocated through the law, mostly a combination of 3 or so defense folks, so to speak, a number of prosecution DA types of individuals, law enforcement individual, and some crime lab directors as well. ANAB, and I've actually looked this up and it's kind of a long mouthful, so ANSI, ASQ, National Accreditation Board, is contracted by the commission just because the commission, as volunteers, don't necessarily have the expertise to oversee crime labs in depth. So they're the contracted body. They're a private, not-for-profit entity, which in turn is accredited itself to conduct oversight of crime labs. So we're all accredited by requirement and to either the ISO 17025 standards or in a case of toxicology, ABFT, but they're mandated to move, I believe, 2022 to the ISO standard. We adhere to the FBI quality assurance standards for all DNA labs because everything that we do from a DNA standpoint, the goal is to get a CODIS profile and get it into CODIS, either do direct comparisons or to be able to develop an investigative lead. Every time we have a nonconformance that impacts quality, it is fully disclosed. We do a root cause analysis. We do corrective action. It's reviewed and closed. We have open meetings, and that is part of the commission. And so it was asked of me whether commission meetings are a cure for narcolepsy. I'm not saying it is, but I'm not saying it is not. We do a technical review of all cases, which includes kind of, for me, the biggest couple of pieces are that we do proficiency testing on all of our examiners, and we include a full technical review, which is a additional full objective review of all of the case file and findings to ensure that essentially another examiner would come to the same conclusions. Okay, so current discovery. Right now, it's upon request only. We did a quick tabulation, just try to compare what the impact is of what we're doing now to what we're going to have to lift with this new law. So roughly, we're doing around 870 cases, which was what we did last year, but that's about 7% of our cases. So you can do the math there in terms of what the expansion will be with the new law. And so typically what we provide is everything in the entire case file. I feel that's really what your case is, so to speak. You're going to have all of your reports, the data, the interpretation, every note. We're mandated essentially nothing is ever thrown away. If you take a picture, even if there's a thumb in there, it's going to be included. Anytime there's a mistake, you get a single cross out with initial so that you can see through it, so to speak, and know exactly what was there. So typically what we'll reveal, as noted, reports, data, notes, any correspondence, everything that's important in a case which is used by the scientist to testify. If I went to court, or as I did, I no longer do because I'm administrator, that's essentially what I took was my case file. Any nonconformity we included as well, and any disagreements we have a technical review sheet when that person does a technical review, and anything that is in there is also included in notes. So that there can be corrections made, that's documented, and that's included in that case file. So essentially, that's what you'd be getting now upon request. So the new law, New York Article 245, and as I mentioned, most of it is under 245.20, roughly from F to K, and including S as well, for a vehicular law. Mandates, and again, this is our legal department. We don't have any lawyers who are in the crime lab, but consulting those that do serve New York State Police. Now discovery will be required on all cases, including those with guilty plea, because if the person changes their mind, in turn, anything that is not discovered would not be usable in court. So therefore, the interpretation is we'll have to provide that on close to 100% of our cases, minusing those which would be for investigative leads, so probably 90 plus. So the new law will be obviously much greater in scope and each discovery is much greater. So essentially that equals a 25 to 50-fold increase in the actual hours for discovery that the lab will be required to give. We are civil servants. It's hard to increase taxes. Nobody seems to like taxes, but so there is a fixed pie of resources. Our mission is scientific, which means other than myself, QA managers and so forth, the majority of our staff is scientific and based, and we do not have any legal staff as part of the crime lab. So all the material we currently generate is for accrediting bodies, and specifically in scientific language, so to speak, so that scientific auditors and those with specialized expertise are the ones who go through our case file. We don't, I mean, in essence, nothing is made in general terms. It's all for the people who are going to be going to court and so forth. Other than our reports, we try to make it easy read, so to speak, and that would be directed at investigators and justice system officials, so they can be something that can be readily interpreted and explained in court. So the new discovery items, I'm just going to sort of go through a bullet list of what is included in the law. A scientist CV being a fancy name for a resume with the publications. 10 years worth of proficiency tests, which we do keep. It's a little bit longer than sort of normal in terms of we are previously keeping one full accreditation cycle, which was 5 years now. We'll be moving to 4 years. Reports, LIMS records. So what LIMS means is Lab Information Management System, and that is really a non-specific term. Everything can be kept in there from quality records through procedures and so forth. Preliminary or final findings of non-conformance. Those can be internal, where we find something that's not quite right. We do a corrective action on it, fix it, and document that, or something that's found in an audit, which we're audited regularly externally every 2 years with DNA and every 4 years with audits ongoing every year. Any conflicting analysis or results by lab personnel, regardless of the lab's final analysis or results. As I mentioned previously, we don't throw anything away. If we do multiple runs, that's all included in the file. And with our tech review, if there are any discrepancies, that's included in the form and any explanation as well. All photographs and drawings. So discovery items, and again, just sort of a Christmas list there. Essentially, everything in that case file jacket, which is what we would be providing before, case reports, documents, records, calculations, writings, preliminary test screening results, bench notes, analysis performed, or stored electronically. And here's sort of the big hook for us, information that can be used to impeach the lab witness's credibility. Sort of an interesting one in that lab, we provide everything on the QA side, but as in most crime labs, we don't have our own personnel. Most crime labs, I'd say 95%, and Matthew can correct me, are within law enforcement agencies. As a result, many do not have their own personnel or legal departments, so that's something that's typically provided by those entities when subpoenas are given. Okay, so forgot the heading on this, and I apologize for that. And this is specifically 245.20S, which is vehicle and traffic law, which is really that much more specific as well. It includes disclosure of instrument records, including repair and maintenance records. Really, I think we're talking about DWI, even though that's not specifically mentioned. And here's kind of an interesting one. Not only a 6-month period before the testing, but 6 months after the testing. So when you think about the logistics of trying to provide records after the testing to try to keep that rolling record of when the actual test was released in 30 and 6 months after the fact, it'll be interesting in terms of how to comply with that one. Operator certification, and I just briefly talked about the 6 months records after the fact. Okay, so just facts and figures in terms of our resources. Right now we're spending about the equivalent of 5 person years to to provide that current discovery in about 7% of requests, so kind of you do the math. Our entire lab system has about 230 employees, and we produce over 12,000 case reports, so essentially about 25 times more labor. So for us, we have a scientific staff with no dedicated legal staff. We have a fixed budget with additional resources included in law. So as you can appreciate, this will be an impact on crime labs. So just in terms of this general decision points, what requirement is being or not being met by the current law, which will be met by or the incoming law? We keep all accreditation records right now, but they are in a scientific format. A lot of them are on paper, and the data is fairly disjointed. We certainly, whenever auditors come in, essentially we wheel all the carts of the paper in. So the assembly of the materials is quite a lift. There's, of course, timeliness, and in many cases, I'll just have to say, the majority of crime labs have backlogs, and we can't obviously provide discovery on something that has not yet been done. So that's going to be a challenge in terms of timeliness to say, well, where's my lab information? We can't generate something on a test that we haven't got to yet. So some big question marks in terms of how that's going to play out. Dissemination is also a challenge, particularly for state police, because we serve over 50 separate DA's offices, and as you can appreciate, we can't pour all of those materials into a pot and let the DA's offices sort them out. There needs to be privacy between cases, so there is going to have to be some distinct separation on a need-to-know basis. So again, back to the math in terms of how many separate discovery packages and how much customization we'll have to do, because part of our requirement is to guard that confidential data. So in terms of a path forward, what we're doing is estimating an amount of hours in the current format, just what is our as-is state, looking at how many hours will be required for the new discovery, and how we're going to meet that at least 25-fold increase in the labor hours. If the discovery law is not met, evidence can't be used in court. Obviously, that's a bad thing. So we'll be doing that calculation, meeting with our DA's offices and various folks in terms of what their interpretation is, meeting as crime lab directors later this week to try to come up with a unified response for across the state of New York. And ultimately, if we don't have the resources administratively, we will have to reassign scientific resources. We have sought assistance with IT, have been informed that that will not be a short-term solution. Reached out to other crime labs, notably Houston. So in Texas, they have an extremely broad discovery law, have for years. And their scientific, they call it e-discovery, where they provide discovery, but it is still upon request. They have 10 full-time IT staff, and it's taken them 4 years to set up their e-discovery. So we have exactly 0 IT staff, and we'll be relying on the state's IT staff. So again, you can sort of see the dilemma in terms of the crime labs of the state. And absolutely current backlogs will be impacted negatively.
Right. The defense point of view is somewhat different than the one that Ray has presented. And the statute that we now are going to have in the state of New York recognizes a wholesale 4.5-decade problem of getting discovery in this state into the hands of defense attorneys. The model in New York has always been that the lab generates the material and turns it over to the DA. The defense has to get its material from the DA. The new statute preserves that model, but with one big difference. Now, the DA is under the gun because there are strict time limits, and the district attorney now has to worry about the discovery statute being pegged to the speedy trial statute. We had a very bad incident here in New York. You read about it nationally. A young man named Browder went to Rikers Island for a crime he was accused of. He spent 3 years at Rikers Island, couldn't make bail, charges were dismissed. He went home and 3 months later committed suicide. Mr. Browder's death was unacceptable to the legislature and to the governor, and as a result, the speedy trial statute is now going to be pegged to the readiness of the district attorney, which means that the district attorney is going to have a new relationship with the labs, totally different than they had in the past. It's no longer going to be you call the lab up, you have the materials, just send over what you have, who's the key guy that we got to speak to, call him into the office, prepare him for trial, and then we're off to the races. Those days are over. That's what this statute pretty much means. So what the statute does is it addresses two big areas. First, the scope of what the defense can get, and then it names specifically what the defense can get in an including but not limited to manner. Second, the statute defines when this stuff has to be turned over. And third, the statute provides for a series of mechanisms, including hearings. And if the district attorney cannot give good reasons why this discovery has not been turned over, they're going to get caught between one of two statutes in the section, 245.80, which is a sanction section, where the DA can be sanctioned. The sanction section of the new law has been really strengthened. Now the sanctions are named. They're put in there specifically. The old sanction section simply said a judge could impose sanctions. So if you said to a judge, I want the case dismissed, I can't do that. If you want the case reopened, I can't do that. If you want the case, the witness's testimony excluded, precluded, et cetera, can't do that. Now all of these things are specified as a laundry list of possibilities that sanctions will fall on the DA. The other part of it is if you're not going to be in the sanction section and you're a DA and you can't meet these strict timelines, then there's a section called 245.70, otherwise known as the protective order section. The real gist of the protective order section is to really cover situations involving witnesses and the protection of their identity. But the statute is worded in such a way that it can cover pretty much any material that the district attorney feels should be subject to protection. Why would the DA want a protective order for forensic materials? The answer is because if the DA can convince a judge that they fall within 245.70, then the timelines for turning over the material to the defense are elongated and made longer. It's our belief that most district attorneys, rather than be caught in the sanctions channel, will, long before they have to, get into the 245.70 area. So let's take a look at what it is that we're dealing with, and then why it's in here, and the timelines. First, the scope. We have had 45 years of trying to get materials. We say we want a recording, we can't get it, it's electronic, you're not entitled to that. It's written on tissue paper, you can't get it. Now, the statute says all recordings, records, reports, data, calculations, writings, it pretty much covers the gamut of three-dimensional capture of discovery. So that's part one. Then it goes into specific things. So for example, preliminary tests and screening results. This is something that we have not seen. The defense doesn't see these things. We just don't get them. If they're turned over to the DA, we haven't seen them. We haven't seen them in upstate New York in over 20 years. Certainly down here, we've seen it on an occasional basis, but we don't see it in a lot of places. Preliminary tests and screenings are followed by bench notes. So bench notes are very interesting because they are the on-the-spot calculations and notes and are often clues as to what was going on at the time of the analysis. Those are preserved, we believe, by the laboratories, but we haven't seen those. And now we're going to be able to get those just because it is mandated that the defense will get those. Analysis performed, those, if they're stored electronically, we will get those analyses as well. Now, in addition to all of this, we're entitled to any scientific tests, experiments, or comparisons. That's as wide as it can get. I don't know if we can devise a human writing that says to the prosecution, talk to the lab, any test you did that's scientific, with respect to this case, you have to tell us. LIMS, the Laboratory Information Management System, I want to tell you a very interesting thing. Probably people in this room know it. I would say conservatively that 90% of the defense bar has no idea what LIMS is. But here's the good news. 95% of the district attorneys don't know what it is. So we're in good shape. I'm not going to deal with the judges because it's a higher number. But LIMS gives you a picture of what happened when the cop brought the evidence through the door, gave it to the first technician, and it worked its way through the lab. An incredibly invaluable piece of information if you're a defense attorney. We had one incident a few years ago in the Commission on Forensic Science where a laboratory worker created a result. The deputy head of the lab didn't like the result. The lab worker went on vacation. The deputy head of the lab changed the result, right? The guy came back from his vacation. He saw that. He enacted the protocol. He went to see the head of the lab. There was a big to-do about it. In fact, it was a big investigation, and there was a report issued. The deputy head was eventually fired. And the question that we had on the commission was, we couldn't find in the LIMS system the notation of when the thing was changed. We were assured that that was going to be in the LIMS system, and it wasn't. And the explanation that we got was it wasn't programmed properly to make that change. That's why LIMS is in this statute. It didn't happen accidentally. Preliminary or final findings of nonconformance. You would think that in the year 2019, nonconformance would be Brady material, right? After all, there's a nonconformity, something goes wrong, it's favorable to the defense. Now, we've lost this culture war with the DAs. The DAs have a different view of Brady than we do on the defense. They have a different view of Brady than the Supreme Court has. We have a different view of Brady than the Supreme Court has. We certainly have a different view of Brady than the New York Court of Appeals has. So here's what the legislature did. Enough, they said. We're going to put in here a whole bunch of things that we say must be given over to defense. We're not going to leave it up to a Brady determination. So from now on, if there's a nonconformity, you've got to give it over to the defense. And by the way, if the nonconformity arises as a result of a conflict with accreditation standards, industry standards, government standards, or laboratory protocols, you've got to turn it over to the defense. And the reason they put in all of those things was because we often used to get arguments at the Commission on Forensic Science that this particular protocol, that didn't apply. Even though it was ASCLD lab at the time, it didn't apply. There was, I went to a conference, we actually had this happen. We went to a conference and a lab submitted to us a piece of paper from the conference that said, this is the protocol we follow. A complete violation of the rules for accreditation. So that's going to be done. Conflicting analysis, regardless of the final analysis or results, must be turned over to the defense. I got this question a couple of years ago from an FBI agent at a conference like this. I think it was at this conference. Said to me, Mr. Schechter, if the first technician says it's a match, and the second technician says it's not a match, and the protocol says go visit the supervisor, and they resolve it that it's a match, where's the Brady material? And I said, the Brady material is in the fact that there was a dispute. The resolution of the dispute does not un-Brady it. Juror number 7, listening to the FBI agent from a lab on the witness stand, is entitled to know that there was a fight and that it was resolved. Now, juror number 7 may say, I love the FBI. The FBI is great. I read Comey's book. I read McQuaid's book. They're great. They're wonderful people. I read both those books. So the bottom line is, it's Brady, and it's going to have to be turned over.
And Mr. Schechter, I don't mean to interrupt
Yeah,
you.
yeah, sure.
But that that information has been turned over for at least the last 9 years that
Good.
I am aware of. That is part of a report, so.
Right.
And secondly, why would you ever listen to an agent?
Well, because I'm one of those people who believes in FBI agents.
Thank you, I'm sorry. I didn't mean to interrupt.
You know, that's okay. So here's some key principles that you should know about in this statute that are going to make it very hard for the DAs to look away from what's going on in the labs. And these are really, some of these are quite astonishing. First of all, the defendant must be allowed to inspect, copy, record all of the stuff that the lab gives to the district attorney. The prosecutors must identify the lab. We've had problems in upstate New York because some of the labs are not equipped in certain parts of the state to do certain kinds of analyses, so they farm it out to other labs. We even have a problem where DAs are not satisfied with the result of a lab in this state, and they go out of state to get it from another lab. That's now covered in this statute. The prosecutor, this is an incredible rule. Under the new statute, the prosecutor is under duty to ascertain the existence of information so as to make all of the materials in the forensic lab, or any materials, available to the prosecutor. A duty to ascertain the existence of information. Finally, and this is really quite incredible, all items and information related to the prosecution in possession of a New York State agency or a local police or law enforcement agency shall be deemed to be in possession of the prosecutor. That's it. It's over. It's over. The whole 4.5 decades of law in which it was maintained by the courts that the labs were independent entities, separate and apart from the prosecutors, finito. At least that's what the statute says. So we'll see whether or not this happens. There are one or two other things that I think are important that are going to make life very difficult for a lot of the parties. One is, into the statute, there is a presumption of openness. It's like marriage, right? It's a presumption of openness, right? And so that's written into the statute. I don't know what's going to happen when this is argued in court. It's not a rebuttable presumption. It's just a presumption of openness. So it says in the notes to the statute, the presumption of openness means that if there's a dispute over discovery, we err on the side of the release of the information. And last but not least, and this is going to be the best of all, I may come out of retirement to do one of these. The judge can now order a conference between the parties before trial in which the parties have to sit down with each other face to face. This is very hard to do with DAs and DAs with defense attorneys, and a member of the court or the court itself, and hash out any disputes over the issue of what can be given over and not given over. Now, I think that's a very good idea. If I were a defense attorney practicing today, I'm going to ask for that conference. And it's not going to be a conference, and here's the only problem. It's not going to be a conference where we go into a room and you say, I'd like the limbs. We haven't gotten it. And the DA turns to me or the judge and says, well, why should Mr. Schechter get the limbs? That's not the conference. That's the kind of conference you walk out of. Because the statute says limbs has to be given to me. The issue is, when are we going to get it? And Ray is right. Of all the materials in this statute that you can get under these strict time limits, and it's 15 days from arraignments. If you're lucky and you can convince a judge you need an extension, you get 30 more days. 45 days from arraignments, you have to give over all of this stuff. I got to tell you, I don't think that a lot of the forensic stuff in some of the big cases can be done in 45 days. I don't think it can be done. So the question is going to be, How are we going to handle that? Either we're going to be professional and we're going to agree that we're going to get it and the speedy trial clock is going to tick, or we're not going to get it, in which case we're going to have to go to the more obtrusive sections of the statute. Thank you.
Thanks, Mr. Schechter. Now move to Paula Wulff.
Thank you. Well, first of all, I have to make the mandatory disclaimer. At one point in time, Matt Riedel was my boss at the National District Attorneys Association. And secondly, everything I say is my opinion, not necessarily reflecting the opinion of the FBI. Glad there are several members of the FBI present in the room to keep me honest. Are there any members of ATF or DEA present? Okay, so everything I say about them is probably a lie. So, having said that, I'd like to respond to just a couple of things that have been said by my colleagues already so that we can focus in on the impact of the change of the New York State statute for discovery. Then I want to talk about discovery in general for how to proceed to obtain discovery from one of the DNA component laboratories, which includes ATF, DEA, the FBI, Secret Service, and Postal Service. I don't know if any of you would ever have a need for that, but they all fall under the umbrella of being controlled by the Department of Justice type of thing with that. First of all, I wanted to say with Ray having said that discovery is only provided upon request, we have found that unfortunately at the federal level, discovery is provided sometimes is requested very late in the game. So we have moved to a process in my unit of the minute an examiner informs us that they are going to potentially be called for trial or that they receive a subpoena, we immediately look up and see whether discovery has been provided at that point. Also, whether discovery has been provided not from just that examiner, but from all the other ancillary examiners who are involved in the case. It's shocking how many times a trial is set. People move very quickly. The trial date may be set for next week, and we discover no one, the prosecutor, no one has requested discovery in this case. In fact, my colleague Jim Agar, who's sitting over here, Jim, if you want to raise your hand, all questions go to Jim after this. I was on vacation last week. Jim told me that there were 3 ASAPs that we received last week for discovery where a prosecutor had not requested the discovery materials. A trial was set for it this week, starting yesterday, type of thing. And I'm going to say shame on the prosecutor, but shame on the defense attorney for not having requested the discovery of the materials for this too. Once you have a trial date set, it behooves everyone in this room who is an attorney to make a request at that time for discovery. And from the federal perspective, the discovery request, we cannot respond because we are a component of the Department of Justice. We cannot respond directly to defense requests for discovery, but if you go through the prosecutor, if you launch that through the prosecutor, and the prosecutor sends us the discovery request, we do our best to get that material to you in a timely manner. I do know that we are launching this week, actually, all of the forensic reports that are going to be issued by the FBI laboratory will carry a disclaimer at the on the front page, hopefully at the top of the report, saying, please request discovery within 30 days of your need for this, because we cannot ensure that you are going to be receiving that material within 30 days, because our discovery is comprehensive. Everything that the New York statute covers is something that we do provide, including, we don't say that we're providing you the LIMS, we don't use that term, although we do use the LIMS system, but we do provide the entire chain of custody, how things flow through the laboratory. It went from this person to that person, et cetera. We've unfortunately had requests from a lot of attorneys of late to call everyone as a witness who handled it, every runner who took the evidence from the evidence control room to the DNA unit, and then from the DNA unit to the next unit, et cetera. And I'm going to question whether that's really necessary for you, but we do provide that information. We provide all the bench notes. We provide all the dispute resolution materials. That's either embedded within the report itself. If there was a dispute between the parties reviewing, the person who created the report and the tech or admin reviewer, that's included in the report, or it's included in the bench notes. all of that material is disclosed because as a forensic laboratory, we are not an arbiter of whether something is Brady or not. We're just a service provider type of situation. It's for other parties to determine the Bradiness or the materiality of that. So we have for a number of years included that, if not in the report, in the bench notes too. So that material, a careful read of the discovery material provided will indicate if there was any kind of dispute. We actually have a process within the latent print unit for that dispute process also, and that is disclosed. What that process is disclosed also within that. So I feel, I'm glad I don't practice law in New York, hearing what all you're going through and the changes, because it is a tremendous resource. I won't say sinkhole, but it's a tremendous demand on resources to provide this. We have a rapidly shrinking staff of being able to provide discovery at the FBI laboratory. All discovery flows through my office, but we have never been faulted for not providing discovery in a reasonable manner when it is requested. At least not to my knowledge. There's never been a complaint made regarding that. So having said that, it is not upon request only. We actually affirmatively provide discovery to prosecutors, whether they request it or not, once we have a subpoena. And I have had instances where, in one particular state, prosecutors have told me, "Oh gosh, I wish you hadn't provided this to me because now I have to provide it to the defense." Well, you know, at the end of the day, you really should have done that. But at the end of the day, the defense should have requested it a long time ago too. So I'm not faulting either party in this. We all have tremendous crushing workloads, but everybody has the burden of asking for the discovery or pushing it forward to us. I want to say that because the FBI is a component of the Department of Justice, our mission statement, if you're aware of it, and I believe ATF and DEA and all the other DOJ component laboratories have very similar mission statements. We are a service provider to law enforcement. That is stated within 28 CFR 0.85 parent G for the laboratory. We provide services to duly authorized law enforcement agencies and to federal governments upon request. So within that, if you as a defense attorney wish to have some work done, if you wish to make a request, that actually has to go through the prosecutor. If we receive a direct request for discovery from a defense attorney, we will contact them and ask for who the case prosecutor is, get that contact information, let them know that we've received this discovery request and that we are going to be forklifting over everything to them as the prosecutor to then determine whether or not it falls within their state requirements as to what they provide for discovery. So sending a request to me directly as a defense attorney is not your quickest way of getting the information that you ultimately are seeking. Work with the prosecutor for this. I mean, you can tell me I've sent this request to the prosecutor and that's fine, but I am enjoined from and cannot provide discovery directly to the defense simply because we are a government agency within that. Having said that, our funding comes from Congress. I don't know, I know that there are fee for service laboratories out there. I know like the Houston laboratory will accept material for analysis from anyone who is willing to pay their prices. And I'm sure that their prices are in line with everyone else, but we are not. We can only accept material for analysis from the government, from the local law enforcement agency, from a tribal law enforcement agency, et cetera. Now, I will say that there was one very close in proximity to you here in New York case in post-conviction where a defense attorney wanted to have the FBI go back in and look at some evidence that we had looked at a number of years ago. And we were very willing to do that, but our process is that request has to come from the prosecutor or the government entity working through this legal issue. That was the Elmer Daniels case from, I think, New Jersey. I know that the Innocence Project, Sarah, you probably have knowledge of this. I know your office has been involved with Mr. Daniels' attorney on this. Mr. Daniels' attorney had sent letters to the then Attorney General, making a request that the FBI do this particular re-looking at this analysis for him, to the Delaware Attorney General, et cetera, et cetera. And it's not that we're not willing to do something, but but being government entities, we have to follow our process. And that process requires those types of requests to come through the relevant law enforcement agency or Attorney General's office, et cetera. Ultimately, that information was looked at again and not on the basis of our findings, but I believe Mr. Daniels' case was overturned. And Sarah, correct me if I'm incorrect on any of those details related to that. Within that, I know that Ray was saying also that you provide proficiency tests for going back for 10 years. We do it for in perpetuity. I mean, it's like the Scarlet Letter. It is something that we feel we must disclose, whether someone, if you're still practicing the same discipline 15 years and your very first proficiency test was a failure for whatever reason, we still have to disclose that for the rest of that individual's career. Now, we will say, although this person failed this proficiency test and this is what this was, that failure may not be relevant to the analysis that individual did in the case before you today. They may have been using a different technique, a different system, something that's no longer like GSR, something that we may not be doing at the moment, type of thing. So it may not be material, but it is disclosed to you. It's also disclosed to you that the fact that the person failed a proficiency test at one point in their career. They're not out testifying until they have demonstrated proficiency in that failed area. So don't feel that a failure from 10 years ago is necessarily the aha moment in your case, because the person has already demonstrated proficiency through retraining, through corrective actions, et cetera, for that point. So while it's an interesting fact, it's not the now the train's off the rails issue with that. Please tell us if you're a New York State entity, a prosecutor, and you're sending information to the FBI laboratory to be analyzed. We won't know about whether or not something is slated for plea or whatever, and your requirements. So please communicate with us that you need to have that information sent to you, whether or not the case is going to trial or not. I actually think that that's quite a brilliant move within the statute, although it's burdensome and quite cumbersome for all laboratories to produce all material in all cases at this point. But it also saves you from circumstances in 15 years when there's a change in technology and because of a plea. I mean, I prosecuted in Memphis, Tennessee, and if someone pled guilty, we really didn't necessarily, in all instances, I'm trying to couch this with all the words of no responsibility. I'd be shocked if a case that pled guilty, if you could still go back and create the full file 15 years later. So, that's a very smart move, but let us know that that's something that you require. Okay. Oh, good. Well, I've blown all my time. Well, let me tell you about other things. We provide SOPs now. I don't know if you're aware of it, but a byproduct of the National Commission was that Loretta Lynch indicated that all federal laboratories would post the standard operating procedures that their analysts used by a date certain, and we have achieved that date certain. So we are currently posting our current procedures online. You can get up there. I provided the website number, it's www.fbilab. This is all one word, lowercase, FBILABQSD.com. That stands for Quality Assurance Documents. And you can look up all the currently, when I say currently, all of the SOPs that are currently being used by the laboratory. The website will say that this is current as of such and such a date. The current material is current as of March 29th of 2019. That will always be updated. You'll always be informed of that. That the legend on that site indicates discovery has to go through the Office of General Counsel, so please make that request through the Office of General Counsel, and if you're a defense attorney, through the prosecutor, who will then contact the Office of General Counsel for that discovery. And that another opportunity for receiving documents that you're looking for if you're a post-conviction attorney that you want to review a case is through the FOIA process. Don't try to do an end run through discovery to get something that we can't provide to you. If for some reason a case is still ongoing, we cannot provide you pending case material through FOIA. That would be through the discovery process. If the case is over and done and it is post-conviction, then your best approach would be to make that request through the FOIA process. And that will expedite getting you the material theoretically within 20 days. I also wanted to speak very, very briefly about testimony monitoring. David Kay will be speaking to you tomorrow about the uniform language in testimony and reports, and I believe Ted Hunt from the Department of Justice will be speaking to you earlier about that. These are specific statements that examiners can or cannot make. We provide that information to you in our online SOPs, and then in the SOPs that are also provided to you in discovery. In other words, if the SOP, posting our SOPs online does not negate our need to provide them to the prosecutor in discovery. So within the standard operating procedures, there is a sheet or several pages that will say an examiner may say the following, an examiner may not say the following. You should read that, because if an examiner is asked a question that falls outside of what they are authorized to state in support of that particular scientific discipline, they will sit there on the stand and say, that exceeds the science, I cannot answer that. And you don't want to be, as a prosecutor, you wouldn't want to be embarrassed that you haven't pre-trialed with your witness, if your witness is the examiner.
Now, those of you who don't know, we have 3 systems generally in a laboratory. We have our laboratory information management system, which is, it's the brain of the whole lab. It has all the data or most of the data. Then most of us have a document management system. Most of us use Qualtrics. That's another system. And then many of us have personnel records management systems that are run by our departments. So all those 3 different records have to come together somehow if we're going to provide that information to you. And Allegheny County made a great presentation last week at the ASCLD meeting talking about how they're providing specifically the information that we've been talking a lot about today. And I will make this presentation available so you don't have to write and things quickly. Arizona, I put this as an example because they're really trying to get into the game, like I think a lot of labs across the country. And this is the direction they're looking at, which is, I think, a really good trend in the country to make these manuals and other things available online. Orange County, they have a very robust IT infrastructure, and this is what they're making available on their website. They take a little bit different approach because they have a public website, they have a login for district attorneys. But again, you have to think, this is one laboratory serving one county. So that's really important when you're looking at a state lab versus county or city lab. They have very different needs for prosecutors, for defense attorneys, and things like that. So I talked about most the software currently is not robust enough to do some of this stuff online. And we have multiple systems. It takes large resources. I want to emphasize that. It's not that labs don't want to comply with these kind of things in most cases. It's that we don't have the resources, especially from an IT perspective, to be able to do it. So hopefully you're the ones that are out there advocating for your labs, saying we need this information, please help them with the resources to get there. Now we also have a problem sometimes that I wanted to bring up, that the inside baseball information, now you're getting so much information that you don't know what it means. So again, dialogue with your laboratories and see what you can learn about what's going on. And then I wanted to finish talking about respect and civility. So it's not an us against them, I hope, anymore. I hope that culture is going away. You know, labs are fighting for resources. They need the resources. They want to help you in prosecution and defense. Talk to your lab and see how you can make life easier for each other. And provide honest feedback. You know, this doesn't work for us. So hopefully they'll work with you on those kind of things. Be reasonable and concise. So if you send us a here, give me everything, you're probably not going to get what you want because we're going to try and interpret what you want. But it's also important to be specific at what you want. If it's a breath alcohol case, don't ask us about blood alcohol instrumentation because we're just going to laugh first. And then we're not going to send you anything because you asked for a blood alcohol instrument when you're on a breath case. So make sure you're asking for the right thing, and if you don't know what it is, then call us. Look at the data, call us and ask intelligent questions, and then we'll try and get you the information that you need. If you don't need a book, if you just need the chapter, don't ask for the book. It wastes everybody's time. You're going to get records back you don't want, and we're going to be frustrated having to provide all of that. And I mentioned have a quick phone call, have a conference call. If you can't talk to the prosecutors without the defense attorneys, whatever, just have a conference call. Have everybody in the room. Somebody mentioned that earlier. I wanted to mention, just in closing, this was a slide that was thrown up by Costa Rican lab director Mauricio Chacon. I thought this was great, and I took a picture of his slide because this is Costa Rica. He came to the ASCLD meeting last year, and he saw that we were making a presentation on transparency. He went home to his own laboratory, and you can see on the right-hand side, that's his version of that in Costa Rica. So when we lead in the right direction, we hope that others will follow, and this was a great thing for me in my lab that he had taken a presentation that we had made at the ASCLD meeting and made it his own. I want to thank our panel today.